Next on the first appearance docket is Andrew James. What's your name? Andrew John James?
Yes.
First name spelled A-N-D-R-E-W?
Yes.
Middle name J-O-H-N?
Yes.
And last name J-A-M-E-S?
Yes.
And your date of birth?
5/24/90.
Thank you. First appearance this morning on charges of attempt to elude and theft in the third degree.
Mr. James, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought. And you have the right to an attorney. Do you have your own attorney at this time?
No.
You do qualify for court appointed. Would you like me to appoint one?
Yes, Your Honor.
All right, let's appoint Gerald Ware. He's going to come forward while I review probable cause.
Morning.
It's like theft 3 and attempt to elude. Probable cause established. Position on release.
The state's requesting $25,000 bail plus conditions. It does appear that he has a criminal history out of the state of Oregon as well as Washington. Most recent conviction, it looks like, is from 2011 and attempted delivery of meth from the state of Oregon. Of note, however, is amongst other felonies is a bail jump conviction from 2008. Bearing on his propensity for reappearance in this case, supervised release wasn't able to verify any reference or residence information. Based on the nature of the allegations, the state would submit the $25,000 bail as appropriate.
Your Honor, the probable cause statement does not come close to containing all of the elements for attempt to elude. I would invite the court to review it.
Say that again.
As the court is aware, the attempt to elude statute probably has more elements than any other charge we routinely see. There's no reference to the officer being in uniform, the vehicle being equipped with the radar and sirens, or there having been used.
I guess I'm a little confused, Your Honor, because it does indicate in the probable cause statement that the officer told the defendant's vehicle to stop when he was attempting to stop the vehicle in a marked patrol vehicle with lights and sirens activated.
Well, I'm not sure, but at this point, I see sufficient information. I'll leave that up to subsequent motion, but I think there's sufficient factual basis there about marked patrol vehicle with lights and siren activated, etc. But in any event, the state's requesting $25,000.
Your Honor, I think that's in excess of what's necessary to assure Mr. James's return. I heard the prosecutor indicate that there's a bail jump conviction in the past. I don't think that is the only consideration the court necessarily needs to make. I think for the charge that has been made, which essentially was a gross misdemeanor theft with the matter that we've just discussed following it, I think that the appropriate bail would be more in the neighborhood of $10,000 rather than $25,000.
Right, thank you. The court considers the factors in Rule 3.2. I think the prior bail jump, even though it's somewhat dated, as well as the concern for community safety, given the allegations about the attempt to elude, 15,000 plus conditions. We'll set to October 14 at 9 a.m. for your arraignment. That'll be your next court hearing, sir.
Item number 12 on the first appearance docket is Niket.
Go ahead.
This is the co-defendant to Mr. James. Is your name Andrea Julia Niket?
Yes, it is.
First name spelled A-N-D-R-E-A?
Yes.
Middle name J-U-L-I-A?
Yes.
And your last name N-I-Q-U-E-T-T-E?
Yes.
Your date of birth?
5/22/81.
Speaking first defense this morning on charges of attempt to elude, offense in the third degree.
Okay, Ms. Niquette, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought, and you have the right to an attorney to assist you in your defense. Looks like you do qualify for court-appointed attorney. Do you want me to appoint one for you? Okay, Steve Rucker. Good morning. I'm going to review probable cause here on these two charges.
Good morning, Ms. Niquette. The judge is looking at this document and this document. Once he's reviewed it, state will make a comment, then I'll make a comment. Judge will discuss release or bail. It's clearly going to be a bail amount. The question is how much. So let's stand by and hear what the judge has to say.
Court does find probable cause. Position on release.
Your Honor, the state's requesting $25,000 bail plus conditions. It does appear that she has felony as well as misdemeanor history out of the state of Oregon, as well as Washington, most recent conviction being a 2015 possession of controlled substance methamphetamine out of the state of Oregon, amongst other felony and misdemeanor convictions. Also has at least two prior failure to register convictions, it looks like, out of the state of Washington, as well as two prior bail jump convictions having bearing on our propensity for reappearance in this case.
Failure to register sex offender?
I was 13 years old.
Stand by.
It appears so, Your Honor.
Okay.
There's going to be just a moment. But based on the nature of the allegations, as well as and also multiple prior warrants having been issued for her arrest, having bearing on her propensity for reappearance, supervised release was unable to confirm any reference to residence information, and for those reasons, Your Honor, the state would submit the $25,000 bail as appropriate.
Mr. Rucker.
Thank you, Your Honor. To join with Mr. Ware's concern about the probable cause statement, although there may be probable cause for reckless driving contained in the statement, the elements of the attempt to elude are not clearly defined there. We'd ask for bail in the amount of $5,000 and a return to court date. The elements would need to be marked vehicle. It says police lights, but it doesn't say the emergency lights or a signal to pull over.
I think that's argument for perhaps a subsequent motion. The court does find probable cause. We'll set bail at $15,000 under the circumstances.
Thank you, Your
Set
Honor.
over to the 14th of October at 9 a.m. for your arraignment.
15,000. Let's you and I go talk, okay? This way, right here.
Item number 4 on the first appearance. Docket is Ambrosia Beasley Haig. Search your name, Ambrosia Shay Beasley Haig.
Yeah.
First name spelled Ambrosia.
Yeah.
Middle name Shea.
Yeah.
And your last name Beezley -HAGUE.
Yeah, that's fine.
And your date of birth?
7/25/86.
Making first appearance this morning on charges of assault in the third degree.
Okay, Miss Beasley Haig, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney. Do you have your own attorney at this time?
No.
You do qualify for court appointed. Would you like me to appoint one for you? Clark Fridley. I'm going to review the probable cause while he comes forward. Assault 3 is the indication. Okay, probable cause established. Position on release.
Or the state would submit $15,000 bail plus conditions as appropriate. It looks like she does have felony as well as misdemeanor history out of the state of Washington. Also has at least one prior conviction out of the state of Oregon. Most recent conviction here in Washington in 2014, possession of controlled substance methamphetamine. Of note, she also has at least 4 prior court order violation convictions showing a propensity not to follow the court's orders in this instance, as well as prior assault in the 4th degree charge having bearing on her propensity for violence. Does also have at least 4 prior cases having gone to warrant status having bearing on her propensity for reappearance. Supervised release was unable to verify any reference to residence information. For those reasons, Your Honor, we are asking for $15,000 plus conditions.
It looks like a Class C felony here today, Your Honor. Apparently, she's been in the community almost 2 years. We would ask the court set no more than $5,000.
All right, court will set bail at $7,500 under the circumstances. Set over to the 14th at 9 a.m. for arraignment.
Could we set that over to next Tuesday, the 6th?
Is that okay, Rhonda? Okay, October 6th,
Thank you.
9 a.m.
Item number 19 on the first appearance docket is Paul Rice. Search your name, Paul Edward Rice.
Yes.
First name spelled P-A-U-L.
Yeah.
Middle name E-D-W-A-R-D.
Yep.
Last name R-I-C-E.
Yeah, and then I use the third. I go by third.
Okay, and your date of birth?
April 23rd, 1961.
Making first appearance on a bench warrant issued for previously filed information. Looks like it's at apartment 3, case charging malicious mischief in the second degree.
All right, Mr. Rice, you have the right to remain silent. Anything you say can and will be used against you.
Okay.
You have the right to a jury trial on the charges the state brings, and you have the right to an attorney. It looks like you do qualify for court-appointed attorney. Would you like me to appoint one for you?
I've already talked to one.
Okay, have you
I mean,
retained?
yeah, I qualify for one, yeah.
Okay, I can appoint a court-appointed attorney for you. If you okay, let's appoint Greco and Downs.
Public defender, is that what you mean?
Correct, yeah. So you're going to get a slip of paper with their name and contact information, phone number, address, etc. Plus, they'll be notified that they have been appointed on your case, all right? So probable cause was previously established malicious mischief second degree is the indication. State's position on release.
And the state's requesting $5,000 bail plus conditions. It does appear that he has criminal history out of the state of Hawaii as well as Washington. Looks like most recent conviction out of the state of Washington is in 2015, obstructing. Looks like also has a prior court order violation showing a propensity not to follow court's orders in this instance. However, it does look like it's fairly old. It's from the mid-90s, Your Honor. Supervised release wasn't able to verify any reference or residence information. For those reasons, Your Honor, we would ask for $5,000 bail.
Mr. Rice, do you wish to respond to the state's request for $5,000 bail?
I can't come up with that. I can come up with $1,000, but that's about it.
The court considers the factors in Rule 3.2, given the nature of the charges and some history and some history of noncompliance with court orders. I think the state's request is warranted. 5,000 plus conditions. We're going to set over to October 14 for your Department 3 date.
It's in here Friday on the 2nd.
All right, let's do that then. Set it to October 2nd for your arraignment.
Your Honor, I'm not even sure what I'm even here for, to be honest with you right now, but I'll find out, I guess.
Malicious mischief second degree. Yeah,
Yeah,
you get a copy of the charge right there that
Okay.
tells the date and what you're
Can't see it right now, so I get my glasses.
1 second while we get you the order appointing the attorney. And you should try to talk to them before Friday morning, okay?
I'm sorry, how much was bail?
5,000?
For yours, sir. That's all for today.
Okay, it doesn't say, what did I suppose it caused damage to?
The charge is right here, sir.
All right, thanks. You're all set.
Item number 8 on the first appearance docket is Jordan Kessel. Search your name, Jordan Paul Kessel.
Yep.
First name spelled Jordan. Middle name Paul. You have to answer yes or no, please.
Yes.
And your last name Kessel.
Yes.
And your date of birth?
January 27, 1991.
Making first appearance this morning on charges of criminal impersonation in the first degree, 2 counts, malicious mischief in the third degree, and theft in the third degree.
Mr. Kessel, you have the right to remain silent. Anything you say can and will be used against you. You have a right to a jury trial on the charges that are brought, and you have the right to an attorney. You do qualify for court-appointed attorney. Do you want me to appoint one for you?
Please.
Okay, Diane Sweet. She's going to come forward while I review the probable cause.
Hello.
All right, court finds probable cause on the first statement of criminal impersonation 1 and theft 3. To be clear, that's the one that pertains to Winco. The second one here pertains to Target.
Are there two probable cause statements? There are.
Court finds probable cause on that one as well. Position on release.
Here, the state's requesting $10,000 bail plus conditions. It does appear that he has felony as well as misdemeanor history of the state of Washington. Most recent conviction in Washington being 2012 trafficking in the first degree and possession of controlled substance.
Sorry, 2012 what?
Trafficking stolen
Trafficking.
property in the first degree.
Thank you.
Supervised release was unable to verify any reference or residence information. For those reasons, Your Honor, the state would submit $10,000 bail is appropriate. The Honorable reserve on bail.
All right, based on that history, I think the bail request is warranted under 3.2, $10,000 set over to October 14 at 9 a.m. for your arraignment. That's your next court hearing, sir.
Item number 13 on the first appearance docket is Michael Rose. Is your true name Michael Andrew Rose?
Yes.
First name spelled M-I-C-H-A-E-L?
Yep.
Middle name A-N-D-R-E-W?
Yes.
And your last name R-O-S-E?
Yes.
And your date of birth?
9988.
Making first appearance this morning on charges of possession of controlled substance felony and criminal impersonation in the first degree.
Okay, Mr. Rose, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney to represent you. You do qualify for court appointed. Would you like me to appoint one for you?
Yes.
Okay, David Schultz. I'm going to review the probable cause while he comes forward.
Sir, you're right to remain silent. I'll talk to you in the back in just a second.
All right, court finds probable cause established. Position on release.
Your Honor, the state's requesting $15,000 bail plus conditions. It does appear that he has felony as well as misdemeanor history out of the state of Washington. Most recent conviction being in 2014, 2 counts of felony possession of controlled substance and criminal impersonation in the first degree. He does have a history of failing to appear prior warrants having been issued for his arrest, had an active bench warrant at the time of his arrest. Supervised release wasn't able to verify reference or residence information, and for those reasons, Your Honor, we are requesting $15,000 bail.
You said 2015 for the history?
2014, Your Honor.
14, thank you. Mr. Schultz?
Your Honor, at this time, based on residence not being verified, I would like to reserve on the issue of bail till his first appearance.
All right, given the recent criminal history, the bail request is warranted. 15,000 plus conditions. We'll set over to October 14, 9 a.m. for arraignment.
Items number 14 and
Thank you, Your Honor.
15 on the first appearance docket is Ricky Sevier.
Thank you.
Your true name Ricky Lee Sevier.
Yeah.
First name spelled R-I-C-K-Y.
Yes.
Middle name L-E-E.
Yep.
Last name S-E-V-I-E-R.
Yep.
Your date of birth.
7388.
Making first appearance this morning on charges of possession of a controlled substance by a prisoner. Also has another case, and he made first appearance on yesterday when Mr. Jones was appointed to represent him, Your Honor.
All right, Mr. Sevier, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on these charges, and you have the right to an attorney to assist in your defense. You don't have an attorney at this time on this charge, do you?
No.
But Mr. Downs was appointed yesterday on your other case.
Yeah.
I'm going to appoint him on this one as well. Then this will be transferred into Department 3. So here's the order appointing him. He'll be notified that he's appointed on this one as well. 1 second, I'll review the probable cause. Okay, probable cause established. Position on release.
Your Honor, bail was set yesterday in the other matter, burglary in the second degree and attempted theft in the third degree at 3,000 plus conditions. We're asking for an additional 5,000 plus conditions on this case for a total aggregate bail of 8,000 plus conditions. Supervised release was unable to verify any, or it looks like they did verify reference information, and unclear whether or not residence information was verified as well. It does have a history of failing to appear, however, at least 3 prior cases having gone to warrant status previously. It does have at least 1 prior conviction, a misdemeanor theft in the third degree from 2012. For those reasons, Your Honor, the state would submit that $5,000 bail on this case for a total aggregate of 8,000 is appropriate.
Mr. Sevier, do you wish to respond to the state's bail request?
No.
Okay, the court will impose $4,000 of additional new bail for a total of $7,500 on the 2 charges combined. The arraignment is set over to the same date as the other case, which would be what date?
The 9th of October.
9th of October.
We need to change order appointing. I put the second.
Oh, okay. So on the order appointing, let's make sure the arraignment date is corrected to October 9.
Is that at 9 or 1:30?
At 1:30.
Thank you for catching that.
Your Honor, you said an additional $4,000 bail?
4,500, I guess.
4,500, okay.
Total of 7,500.
Thank you, Your Honor.
Combined.
That's all for today, sir.
Thank you.
Item number 11 on the first appearance docket is Stacy Myers. Ms. Myers is in custody. She's not been transported down at this time. Your Honor, I'm handing forward a motion in order of exoneration and asking that we strike her from the transport list this morning. Item number 14 on the criminal docket is Darcy Zadunich.
This is on for a diversion referral this morning. Your Honor, I reviewed the diversion referral paperwork with her. With her speedy trial. She understands everything in there.
All right, that's okay with you, Ms. Zadunich?
Yes, it is.
See if you can get your case resolved through diversion. Sometimes that's a good way to go. In order to do that, we'll need a speedy trial waiver. You're agreeing to do that?
Yes.
There's no commencement date in there yet. Shall I fill in, November 30th or December 1st as a new commencement date?
December 1st would work, and then we'd be asking for an additional speedy trial waiver at the time of...
Could we do it before November 15th? I'm going to be out of town for 3 weeks beginning November.
I just mean for the commencement date. Is December 1st okay as a commencement date?
Date's fine, yes.
That's only 3 weeks away. I don't think that's enough time.
No, the commencement date would be fine as far as the December.
Then the question is for coming back for review.
Tuesday.
We could do November 10th at 1:30.
Okay, that'd be perfect.
Okay, so ma'am, it's okay with you to set your commencement date to December 1st?
Yes.
Starting a new 90-day clock? You can't complain that it's taken the state too long to bring the case to trial. That's okay with you?
Yes.
Right, and you'll have to come back then on November 10 at 1:30. Hopefully that's enough turnaround time. It's a little bit tight, but they might have it done by then.
Thank you, Your Honor.
So that's a court-ordered return date.
Okay.
You're still under whatever release order conditions are in effect as long as the charges are pending.
Okay.
Get a copy of the paperwork.
1 second, you'll get a copy of these 2 orders.
number 12 on the criminal docket is Cartier Franklin. Mr. Franklin is in custody, has not been transported down at this time. I'm told, Your Honor, that matter is going to be a strike this morning, set over to the readiness hearing date of October 2nd at 1:30. That's the on their list as well.
Okay, 12 is stricken.
Item number 9 on the first appearance docket is Kelly Lawson. Is your true name Kelly Christine Lawson?
Yes.
First name is spelled Kellii.
Hi. Yes, please, then.
Middle name Christine.
Uh-huh.
And last name Lawson.
S-O-N. Yep.
And your date of birth?
11/14/66.
Making your first appearance this morning on charges of malicious mischief in the first degree domestic violence.
Okay, Ms. Lawson, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney. Do you have your own attorney at this time?
No.
Okay, you have not qualified for court-appointed attorney, so unless and until you do so, I can't appoint one for you. However, I certainly recommend that you do get an attorney on board to represent your interests. They have the training, the experience to speak for you in court, okay? One moment while I review the probable cause. Malicious mischief, first degree, domestic violence is the charge. Okay, probable cause established. Position on release.
Your Honor, the state's requesting $10,000 bail plus conditions. It does not appear that there's any known criminal history. However, supervised release was unable to verify any reference or residence information. For those reasons, Your Honor, we are asking for $10,000 bail plus conditions, specifically no contact order with the alleged victim.
All right, ma'am, do you wish to respond to the state's bail request for $10,000?
No, I guess not. No.
Sorry?
No.
Okay. Given the nature of the allegations, I think it is warranted, so I'll authorize the $10,000 bail. The state is also asking for a no-contact order with respect to Daniel Lawson. I guess that's your ex-husband. I'm going to order that, ma'am.
Okay.
Prohibits you from getting within 500 feet of him or having any contact. That's direct, indirect, electronic, through third parties. Any violation of this alone in and of itself could be grounds for new criminal charges. It's very serious. You're going to get a copy of it. If you have any questions, you should talk to your attorney about it. We're going to set over to October 14 at 9 a.m. for your arraignment. And to confirm counsel, again, I strongly recommend you get an attorney on board, okay?
Can you just sign it there?
Am I being released today?
No, your bail is set at $10,000 plus conditions. So when you post, you'll come back to court and we'll set conditions for you, okay?
Okay.
Item number 10 on the first appearance docket is Lamina Mauricio. What's your name? Lamina A. Mauricio?
Lamina.
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 Is that the correct spelling?
Yes.
And your middle initial is A?
Yes.
What's it stand for?
Alicia.
Alicia?
Yes.
And your last name Mauricio?
Mm-hmm.
You have to answer yes or no, please.
Oh, yes.
And what's your date of birth?
4/24/84.
Making first appearance this morning on charges of felony harassment, domestic violence, and theft in the second degree domestic violence.
Ms. Mauricio, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney. Looks like you do qualify for a court-appointed attorney. Would you like me to appoint one for you? Do you want an attorney appointed?
Yes.
Okay, Gerald Weir. He will come forward while I review the probable cause statement.
Good morning. That's my card. That's my office date. I crossed out his name because I don't have it. So you have bruised ribs. You have a place to live? Hello? No. Have you been living on the street then, or are you on probation or supervision or anything? Do you have prior convictions? Don't. Can't turn around.
All right, probable cause established. Position on release.
Your Honor, the state's requesting $5,000 bail plus conditions. It does appear that she has at least one prior misdemeanor that's currently pending from 2014, a driving while suspended. Does have at least one warrant having been previously issued on this case. Supervised release was unable to confirm any resident reference information. She indicated that she goes
So
back and
you
forth
don't
from
have any
Michigan
place to
for
live?
approximately the last 3 months, so the state has some concerns about ties to the local community and propensity for reappearance. For those reasons, Your Honor, the state would submit $5,000 bail as appropriate. We'd also be asking for no contact order with the alleged victim.
Pardon me?
I'm so suburban. It's not like saying he's been a 10. So weird.
Your Honor, I'm not certain why this individual is in the smock she's in. I'm unclear on that, but the most I heard from the prosecutor just now is she's allegedly got a pending driving while suspended charge. We don't see that too often in felony court with virtually no record in terms of convictions. I think that, the charge that has been brought, I've taken a brief look at the probable cause statement. Sounds like it might lend itself to a disposition other than a felony. I would ask the court set a very minimal bail. I know that the state asked for $2,500, or excuse me, $5,000. I'm asking for $2,500.
All right, thank you. I think, given the nature of the charges, there's some concerns about safety here. $2,500 does seem appropriate, though, under the circumstances. State is also requesting, and I'm going to grant a protective order, ma'am, and no contact order with respect to Samantha. I guess that's your sister. So it prohibits you from getting within 500 feet of her or having any contact with her. That's first direct, indirect through third parties, electronic. I'll remind you that all the phone calls at the jail are recorded. If you were to violate this order, that in and of itself would be grounds for new criminal charges against you. So you will get a copy of that. Your arraignment is set over to October 14, 9 a.m.
I gotta be in the Freda on the 15th.
Excuse me?
I have to be in the Freda on the 15th.
Freda, what's that?
Freda.
Oh, Freda. Well, you're not going to make it unless you make bail. All right. So what this is there's no contact order prohibiting, as the court just told you, contact with your sister either directly or indirectly or through a third party. And so if you do have contact in violation of that, you potentially could be charged with a new crime. Understood?
What if she comes by me?
You run the other direction. And hopefully have a witness that you've done the right thing with you.
So that's what they do to us. They come by on your house and get us in more trouble.
Say that again?
That's what they do. They do this and then they come by us and get us in more trouble.
Okay.
Item number 17
Let's
on
go
the
back
first
and
appearance
talk.
docket is
Okay.
Grab that stuff.
Latonga Tamoya. Reserve your name, Latonga K. Tamoya.
Yes, sir.
First name spelled Laufilitonga.
Yes.
And your middle initial K?
Yep.
What's it stand for?
Kagavuna.
Can you spell it, please?
Kaakavuna.
And your last name, Tamoua?
Yes.
And your date of birth?
5178.
Making your first appearance this morning on charges of felony domestic violence, no contact order violation.
All right, Mr. Tomoa, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought, and you have the right to an attorney to assist in your defense. Do you have your own attorney at this time?
No, Your Honor.
Would you like me to appoint one for you?
Please.
Okay, let's appoint Mr. Terry. And review the probable cause for the no contact order violation charge. Okay, probable cause established. Position on release.
Here, the state's requesting $40,000 bail plus conditions, specifically a no contact order with the alleged victim. It does look like he has a criminal history out of the state of Washington as well as Oregon. Of concern out of the state of Washington is 12 prior court order violations showing a propensity not to follow the court's orders in this instance. Also has a history of failing to appear at least 6 prior cases having gone to warrant status. Supervised release was unable to verify any reference to residence information, and for those reasons, Your Honor, we are asking for $40,000 bail plus conditions.
Your Honor, this is, appears to be a non-violent incident. I'd ask Your Honor to consider a much lesser bail. Scene. Looks like the last charges in 2013 as well, so I'd ask Your Honor to consider $10,000.
All right, court considers the factors under Rule 3.2. Both sides have some merit to their arguments. 15,000 plus conditions. We'll set arraignment to October 14 at 9 a.m. In the meantime, Mr. Tomoa, the state's requesting, and I'm going to grant a new domestic violence no contact order with respect to Ms. Nico. Prohibits you from getting within 500 feet of her or having any contact whatsoever. That includes electronic, indirect, or through third parties. I'll remind you all the phone calls at the jail are recorded. You'll get a copy of that order, but if you were to violate that order, that in and of itself is grounds for new charges against you. So it's very serious. If you have any questions, please talk to your attorney about it. Okay?
Do you want to sign this new order here, sir?
Is the same one I had this no contact order with it?
We'll talk about that. This is just acknowledging your receipt of the new order. Okay, let's go back to the chat.
Item number 7 on the first appearance docket is Robert Johnson.
Robert Johnson.
Switch your name, Robert Kevin Johnson.
It is
First name spelled R-O-B-E-R-T.
R-O-B-E-R-T.
And your middle name, K-E-V-I-N. You have to answer yes or no,
Yes.
please. And your last name, J-O-H-N-S-O-N.
Yes.
And what's your date of birth?
7/20/64.
Making your first appearance this morning on charges of robbery in the second degree, possession of a controlled substance, and assault in the third degree.
Mr. Johnson, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to a lawyer to assist in your defense. Do you have your own attorney?
No, I don't.
You want me to appoint one for you?
Please.
Okay, Steve Rucker. He'll come forward while I review the probable cause.
Good morning, Mr. Johnson. This is the document the judge is looking at right now. Doesn't require there be a showing of proof beyond a reasonable doubt for the probable cause. It's just enough whether to move forward to an arraignment and setting a trial date. Judge will review this document here from the state.
Probable
here from
cause
me.
established. Position on release.
Your Honor, the state would submit $40,000 bail plus conditions as appropriate. It does appear that he has criminal history out of the state of Washington with his recent conviction suspended charge. It does appear that the history is mainly misdemeanor history. Does have prior fugitive holds, though, and prior failures to appear, at least 7 prior bench warrants having been issued for his arrest. He had 3 active bench warrants at the time of his arrest for this incident. Supervised release was unable to verify any reference or residence information, and for those reasons, Your Honor, we are asking for $40,000 bail plus conditions.
Thank you, Your Honor. First of all, we did hear that the history was misdemeanor history. The allegations, although serious, are only allegations at this point. Under 3.2, we'd ask for bail in the amount of $25,000.
All right, thank you. The court considers the factors under the circumstances. I think defense request is reasonable. 25 plus conditions set over to October 14 at 9 a.m. for arraignment.
Let's you and I go visit about this, okay?
Sure.
So this, thank you, Your Honor.
Item number 5 and 18 on the first appearance docket is William Cloud. Your true name William Hill Cloud.
Yes.
First name spelled William.
Yes.
Middle name Heal.
Yes.
And your last name Cloud.
Yes.
Your date of birth?
9/17/96.
Thank you. First appearance this morning on charges of possession of stolen motor vehicle and possession of burglary tools. Also has an existing case in which Mr. Schultz represents him currently on for diversion confirmation set over to October 6th, Your Honor.
Okay, Mr. Cloud, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney. Looks like Mr. Schultz is representing you on the other case. Shall I appoint him on this one as well, then?
Yes.
Okay. And he's here right now. I'll review probable cause, possession of stolen vehicle, and possession of burglary tools. Probable cause established. Position on release.
Your Honor, we're asking for $15,000 bail on the new case. It appears that he does have a 2013 looks like conviction for possession of stolen property in the 3rd degree. Also have the pending felony case, which was referred to diversion. Supervised release was unable to verify any reference or residence information. For those reasons, on the new case, we are asking for $15,000 bail plus conditions. On the old case, we're asking to revoke the prior release. He was just on supervised release and reset bail in that matter at $5,000 plus new conditions. If bail is posted for a total aggregate bail of $20,000 plus conditions, Your Honor.
And the
Supervised release has something additional to add. We
Go
do
ahead.
not have anything additional, Your Honor. We're also recommending revocation on this pending charge.
And the basis for the violation is the new charges?
Yes, Your Honor.
Correct. Okay, Mr. Schultz.
Yes, in response to start with the issue on bail, his mother is here and be able to verify his residence. It's the same residence he's been staying at. In the previous case, he made all his court appearances. He's maintained regular contact. He'd been in regular contact with the diversion unit. And so as far as his demonstrating an ability to come in and make it to his court dates, I think he's done that over the course of the last few months. And again, his mom is here if corrections wanted it, or supervisors wanted to speak with her regarding his current whereabouts. Beyond that, I haven't reviewed the probable cause statement. I'll have a chance to do that in a second. If that's the basis for the revocation, just request to reserve on that until we're back before the court.
And just to confirm, the new charges is based on conduct post-release on the prior case?
Correct, Your Honor.
Okay. All right, under those circumstances, the state's request is reasonable. $15,000 on the new case, revoke release, and set bail at $5,000 on the other case for a total of $20,000 aggregate bail. And then, do you want to set over also to October 6th, Mr. Schultz, for arraignment on this?
Actually,
Your Honor, this was on for
the
it was on for October 6th on the out of custody docket with the idea of diversion confirmation. So we'd asked to strike that date and set a new arraignment date.
Why don't we do the 14th then, October 14th, 9 a.m. for arraignment?
Your Honor, I have a Skamania County dependency docket on the 14th, but I am available on the 13th if that date works.
Should be okay.
it'll be Judge Lewis, but
Actually, that might be an issue.
or would you like to do the 15th instead?
The 15th I could do if it's towards the end of the docket. I'll be
15th, we're outside of speedy, though.
No, it is.
Is your client willing to waive speedy arraignment?
How about we'll just do it on the 13th in front of Judge Lewis? I think he can take a not guilty plea at that time, Your Honor. That'd be the only thing they're requesting that in court dates. As long as the state doesn't have an issue.
No.
All right, 13th, 9 a.m. That is within speedy.
The 13th?
Yes.
Judge Lewis and I used to work together before he became the judge. That's why we had that discussion.
And this is transferred into Department 1 then, the new case? I think the underlying case is Department 1 case.
It is. So this is to them.
Yeah. Just to be clear, even though Mr. Schultz is now in our group.
Item number 16 on the first appearance docket is Colby Shanklin. Is your true name Colby James Shanklin?
Yes.
First name spelled C-O-L-B-Y?
Yes.
Middle name J-A-M-E-S?
Yep.
And your last name S-H-A-N-K-L-I-N?
Correct.
Your date of birth?
December 8th, 1987.
Making your first appearance this morning on charges of residential burglary, domestic violence, and theft in the third degree domestic violence.
Mr. Shanklin, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney. Do you have your own attorney at this time?
No, I do not.
Okay, it's deferred as to whether you qualify for court-appointed attorney or not. Do you have a job? You're unemployed?
Yes. I am unemployed.
All right, would you like me to appoint an attorney for you?
Yes, I would.
It's Department 2, Mr. Fridley. All right, probable cause established, position on release.
Your Honor, the state's requesting $50,000 bail plus conditions, specifically a no contact order with the alleged victim.
2407.
It does appear that he has criminal history out of the state of Washington, albeit it does appear to be misdemeanor history. The concern, however, is that all four of his prior convictions are domestic violence convictions, and does cause some concern for violence given the nature of the current allegations. He does have 2 assault in the 4th degree, domestic violence, harassment, domestic violence, and stalking, domestic violence. Supervised release was able to verify reference and residence information. However, the reference information that was provided indicated that he was actually moving that day. So we do have some concern about ties to the local community and the residents if he's moving out of the prior residence. For those reasons, Your Honor, the state would submit that $50,000 bail plus conditions is appropriate.
Yeah, I can say that. Of course.
Yes, Your Honor, it appears he's a lifelong resident, Clark County, approximately 27 years. His past criminal history is fairly old, it appears. He says that he can still reside with his father, that he does not have to move. So we'd ask the court take that into consideration and set no more than $5,000 bail.
Court considers the factors under Rule 3.2. I think given some history and some public safety concerns, court will set bail at $25,000 under the circumstances. Set over arraignment to...
We do the 6th, Your Honor, October 6th.
October 6th at 9 a.m. Okay, the state is requesting, and I'm going to order Mr. Shanklin a domestic violence no contact order with respect to Jalen Cage, so that prohibits you from getting within 1,000 feet of her or having any contact, direct, indirect, through third parties, electronic, you name it. All the phone calls at the jail are recorded. If you were to violate that no contact order, that in and of itself would be grounds for new criminal charges against you. It's very serious. Do you understand that? We'll get a copy of it. You can talk to your attorney if you have any questions.
What's the bail? So what am I signing here? Is this a no contact order?
Item number 8 on the criminal docket is Joshua Ball.
Thanks. Your motion, counsel?
It is, Judge. We have started interviews on this case yesterday. We still do have other interviews to do, and then after that point, there may be the necessity to get an expert on board. At any rate, we're asking for a continuance so that we have more time to just prepare the case for trial.
State's position?
Your Honor, I don't have any objection to that. This is the first trial setting, so if counsel needs more time, that's probably appropriate.
Is your client willing to waive speedy to facilitate the request then?
Yes, Judge.
Setting a new commencement date of when? Today?
Yes.
Right, if that's...
I mean, it depends on the dates that the court has. We can accommodate that.
We can give you dates in November or December. November 23 or 30 are available in Department 4.
In November?
Yeah. How about November 30?
Is there...
I was going to say, the week of November 23rd, I'm out of the office. The 30th would be okay with me, but I'll defer to court and counsel on that point.
And if I can just look, Judge, at my calendar real quick,
Sure. Or December 14.
And after that, it would be the 14th? Okay. When they work, they're great, but when they don't. You know, Judge, I'm going to say that I think that the 30th would work fine.
Let's take that then. November 30th, if we use today as a new commencement date, that is 61 days out. Readiness would be on November 25th. So Wednesday readiness because of Thanksgiving.
At 9 a.m.
9 a.m. Thank you.
Doesn't have no
So
date
that's
on
okay
it?
with you, Mr. Ball, to waive your speedy trial rights and set a new commencement date of today's date?
Yes.
It gives the state 90 days from today to bring the case to trial. You can't complain. It's taken them too long. You're still under whatever release order conditions are in effect as long as the charges are pending trial.
Call me to go to Seattle.
We'll deal with that if that happens. I don't.
I need to sign this? Or?
Yes, right there. And Judge, I just would want to note for the record, I'm trying to recall if I told Mr. Smith or not, but I know that Mr. Smith knows that Mr. Ball has some medical issues. He's has a number of oncology issues and doctors going on. And what he was just mentioning is that this should be fine, but if for some reason there's a treatment or something that conflicts with that, I guess we'll come back to the court and kind of address it.
Okay.
Yeah. Oh,
Mr. Ball?
Josh. He asked me if I wanted something. I thought.
Oh, I see. All right.
I don't think he
I wanted
realized.
to make sure he wasn't going to leave before we completed
I don't think
the
he
paperwork.
realized I didn't want it right now. Oh yeah, I don't need it right. Let's get through with this real quick. I didn't want you to go get it right now. That goes back to them. That's a copy for me. And then there we go. Thank you, Judge. Oh.
Oh, the waiver he didn't.
Oh, I thought I'd looked and it was. I'm sorry.
Let's reassemble
We have to
it.
put them back together.
Thank you for catching that.
Okay. Thank you for that.
And I need to be going to Seattle for them to start testing me and all kinds of stuff anytime.
Just keep me posted because I think your person. Thank you.
Item number 9 on the criminal docket is David Kessler.
This has got copies of my court dates and stuff.
Yes. On this one.
Thank you, Your Honor.
Morning, Your Honor.
Good morning.
Well, Your Honor, Mr. Kessler is appearing today in 15-101-02-5. The matter was noted up this morning for the defense motion to continue. We're currently set for trial next week.
Your Honor, I would indicate that we've been trying to make arrangements in reference to the alleged victim in this case, and last week we had at least 2 interviews that were canceled. We were able to finally interview the alleged victim on Monday. There are, though, apparently there's an expert, the doctor in this case, and also the police officer involved in those 2 interviews. I think the officer's been scheduled, but we don't yet have any interviews set up for the doctor, and the medical reports were just provided on Monday. So I'm going to need additional time, given the nature of the charges and the critical issues relative to the additional witnesses that I need to know prior to the trial, to ask the court to reset the trial date. I know Mr. Kessler would like to get this matter over with. I explained to him where I'm at, so I don't believe he's wanting to sign a waiver of speedy trial, but I do need additional time to be adequately prepared with those facts, Your Honor.
Okay, Mr. Kessler, are you willing to waive your right to speedy trial to allow your attorney to adequately prepare for trial?
Is it going to be like next week?
Well, we're going to set it beyond next. I'm asking it go beyond next week, probably a couple weeks.
We could probably give you a fairly short continuance.
All right.
Is that okay with you?
Yep.
Let's have a speedy trial waiver then.
That work for you?
It's up to you. I just,
Department
you
4,
already
I've
want
got
to, so.
dates available. We could give you October 26th, which is the nearest one we could give you. Well, there's the 12th. But
Your Honor, I know that there's another case that Ms. Stauffer and I have that was just set on to the 26th. That case has been pending for a much longer period of time, so I'd like to, if we could avoid that date, that would be good.
okay, then we got October 12th, which was a very quick turnaround still. I don't know if that's sufficient.
Well, we're back to my understanding right now. The sheriff officer interview isn't even scheduled for the 9th, and that's not going to
So
give me
then
enough
and I
time.
know Mr. Smith isn't good for November 23rd, so then we're looking at November 30, which we just set one for you for that date.
That's correct.
November 30?
Either date's fine.
Okay. So why don't you set today as the new commencement date?
Today, Your Honor. Okay.
That's November 30th is then 61 days, which is actually 60 days because it's the Monday trial set.
60 days?
Well, let's make the speedy trial waiver October 1st then, if that's okay, sir. That puts us okay. So it's exactly 60 days to November 30th. Readiness November 25 at 9 a.m., which is a Wednesday morning readiness because of Thanksgiving.
Thank you, Your Honor. Okay, sign right there, and you get a copy of that.
You just need to sign that, sir.
This is just a copy of the order approving the continuance there. Here's your 2 copies. Okay?
Yes.
Thank you, Your Honor.
Item number 20 on the first appearance docket is Dorinda Gibson.
I need that order.
Okay, Ms. Gibson, it looks like you have posted a bail bond for the amount of $5,000. Have you gone over these release order conditions with Ms. Welch?
Yes, I have.
And you realize that these are the conditions upon which you'll be let out on release while your charges are pending trial?
Yes, I
That
do.
if you violate any of these conditions, your release can be revoked, you can be brought back into custody. You understand all that?
Yes, sir, I do.
Okay, all of these apply, and you'll get a copy of it, but in particular, I want to go over some of the conditions. First, no contact with any Home Depot store.
Okay.
Second, you have to report immediately to supervised release when you get released. Don't just walk out the door, and then continue to follow all the reporting requirements until the date of trial or resolution of your case.
Okay.
You have to live at the address there on 72nd Avenue in Vancouver with your father and make all your court hearings. When's your next court hearing, ma'am?
On the 9th at 1:30?
Correct. If you don't make your court hearings, that's a violation of this order, but it's also a new crime of bail jumping, which you certainly don't want, correct?
That's right.
So we'll see you back on the 9th at 1:30?
I think so. Yeah.
Item number
I'll give you
17 on the
another one.
criminal docket is Tyler Banning.
Okay, have a seat.
All right, Mr. Banning, it looks like you posted a bail bond for $7,500, so have you gone over these release order conditions with Ms. Welch?
Yes, Your Honor.
And you understand that these are the conditions on which you'll be released while your charges are pending trial, but if you violate any of these conditions, your release can be revoked, you can be brought back into custody. Understand that?
Yes, Your Honor.
All of these apply. Let me cover some of these particular ones. First, you have to report to supervised release. Don't just walk out the door. Continue to follow all their reporting requirements until the trial or resolution of your case. You have to reside at the address there on 23rd Drive with your parents in Vancouver and make all your court appearances. When's your next court hearing?
29th of October.
1:30? That sounds like readiness.
It is, Your Honor.
Okay. If you don't show up for your court hearings, that's a violation of this order, but it's also, more importantly, a new crime of bail jumping, which you certainly do not want, correct?
Yes, Your Honor.
Okay, I'm just going to give you my business card again. Call me when you get out. Leave your phone number with my secretary.
Got it.
Okay, good luck.
Thank you. Appreciate it.
Item number 2 on the criminal docket is Trevor Knowles.
Morning, Your Honor.
Good morning. Knowles.
Your Honor, my recollection is this matter was on for review because we were having difficulties in getting the alleged victims available for interviews, and they were up in Spokane. Since that last hearing, we have been successfully able to do the interviews, and I think we're just looking at a couple more interviews yet to complete with law enforcement to be prepared for trial. So I'm okay at this point in terms of where we're at with the process.
Yes, Your Honor. So this is 15-100-127-1. We were on for readiness for the trial date on the last occasion. The defense moved to continue. The state objected because actually at that point the victim interviews had occurred within a day or so. Judge Lewis granted a continuance, however, was concerned about basically there being further delays in the case, so we set this review. From the state's perspective, we're tracking along for trial on the 2nd of November, and that's the state's expectations at this point.
All right, sounds like things are on schedule and on course then. No other action taken today. Next court appearance presumably then is readiness hearing?
Yes.
Okay, so you're still under whatever release order conditions are in effect, sir. We'll see you at readiness.
Okay. Thank you, Your Honor.
Thank you.
Okay.
Item number 15 on the criminal docket is Andre Kennedy. Mr. McCarty. Kennedy.
Omnibus.
Matter is on for omnibus, Your Honor. Mr. McCarty and I have exchanged omnibus applications. It appears as though the court will need to set aside some pretrial time for 3-5 hearing, but also very possibly an anticipated Fourth Amendment motion as well, which I have not filed because I'm still waiting for some discovery.
Okay, anything with respect to the omnibus applications that the court needs to address?
Nothing from the state, Your Honor. I believe they're all agreed upon items.
I think the only thing is what I previously mentioned, that we'll need to probably a couple of hours at least for pretrial hearing time.
2 weeks before trial, is that sufficient for completion?
Yes, Your Honor.
And so do you want that time set now then? You want to?
Yes, I think that would make sense.
A half day that we could provide to them?
November 2nd, I believe. Is that right?
Yeah.
Yeah.
We could do October 16th at 3 o'clock.
That would be okay with defense.
One moment, please.
That's a Friday afternoon.
October 16th at 3 o'clock? Yes, that works for my calendar.
Very good. Let's set that.
And please just make sure we get a bench copy of whatever.
It's a 3-5 hearing requested by the state, and I anticipate a suppression motion may be occurring as well. The other matter, Your Honor, that I wish to take up, and I advise Mr. McCarty of this, is that Mr. Kennedy was arrested, bailed out, and then on Monday, I believe, was rearrested for matters of attempt to elude and possession of stolen vehicle that were referenced in the original police report. I think the police officers, quite frankly, didn't care for him being released from custody. Yesterday, he appeared without counsel. I was appointed on the new matter. It's not before the court. It's just Judge Vanderwood's case at this time, and a $15,000 bail was set. Today, I'm requesting that the bail be reduced to $7,500. There isn't any violation of his supervised release because the allegations that are now recently made preceded his original arrest, so he hasn't done anything to justify a supervised release revocation matter. In fact, I think that the matters that he's now facing, or which are yet unfiled, should have been filed if there was probable cause at the time of the original matter. So there isn't, he posted bail, he spent that money. Now the law enforcement has put him in a position of having to post additional bail when that, frankly, I don't believe should have occurred. So I'm asking the court, in light of all that, to consider reduction of the bail to $7,500. He's out on supervised release on the original charge, hasn't violated it, and I think it would be an appropriate reduction.
Was the case from yesterday, was that then transferred into Department 2, I presume?
For whatever reason, it wasn't. I have it coming back on the 9th for arraignment.
It is coming back on the 9th, but I believe it was transferred to Department.
You've been appointed on that one?
Yes.
Yeah, okay. Response to Mr. Ware's request.
Regarding that, Your Honor, Mr. Ware is correct that the case that the defendant made first appearance on yesterday, the offense dates do precede his release, and I believe the filing of the other charge, the case that we're present here today on. But the court was aware of that yesterday, and the state did not move to revoke the bail on this current case yesterday. We simply asked for an appropriate bail to be set on the new charges based upon the nature of the allegations and the defendant's overall criminal history. That's what was asked, and that was what the court did yesterday. It said the $15,000 bail. As to the other part of what Mr. Ware was asserting, law enforcement at the time Mr. Kennedy was arrested on this burglary case, law enforcement was aware of the potential of the other charges. What I can't say one way or the other yet for the court, because I haven't had a chance to evaluate everything this year, is if they obtained additional information while this case was going on. I don't have the answer for the court.
So burglary was the original, the charge?
That's the case we are here in front of Your Honor.
Okay. And then there's the addition of the attempt to elude.
Which preceded the burglary allegation.
All right. And he was without counsel yesterday.
That's correct. He spent $3,500 for the bail, and now it probably would have been a similar bail had everything been charged originally, and now the request is to cost he and his mother more bail, and I think it's transparent what has occurred here.
Well, it may be. I don't know the full story, but giving some benefit of the doubt to the defendant here, we're going to reduce that $7,500 down to the $2,500.
$2,500 on the new charge.
Correct.
Thank you.
With 15 now.
Right, 15,000. 2,500 is different.
Oh, thank you. Thank you, Your Honor. Thank you so much.
You're welcome.
Do we need to?
Yeah, it's not this case. It's an unfiled case.
Right.
Yeah. It's over to the 9th, that particular case.
At 9 a.m., right?
No, 1:30.
Thank you so much, Your Honor.
Like that. So now you'll like to do that. A memo on the bail reduction? Yeah.
I'd be happy to step aside and fill out the memo.
Thank you.
Item number 16 on the criminal docket is Michael Hatch.
You'll be brought back up in a moment.
Mr. Hatch comes on today, 15101714-4 for omnibus. Mr. Schultz and I have exchanged applications. I note the defense response is defenses of necessity, self-defense, and defense of others. Other than that, I think the only thing we would need would be a compliance date. I would propose 2 weeks in advance of the eventual trial date.
Is that agreeable with you, Mr. Schultz? Looks
For
like
the
November 9 trial date?
Yes, Your Honor. For the most part, it's regarding the general nature of the defense. I haven't had a chance to fully review the state's discovery. I had checked the other day, and I don't believe I've been provided everything. It was also my understanding that the investigation was ongoing. So at this point, with information I have, which mainly comes from my own independent investigation into the matter, I intend to assert the defenses of necessity is probably the most appropriate, self-defense and defense of others, just kind of overlapping based on where the charging is at now. Necessity is probably the most appropriate. In regard to the omnibus application filed by the defense, we were also requesting that bail be lowered. It was set at a relatively high amount as more information has come to light. However, I think on that I'd reserve on the issue. I was anticipating that I was going to have police reports and be able to update the court as to the status of the case. However, until I review that, I'm not in the greatest position. So on bail, I'd request to come back.
You can bring that before the court on subsequent motion. I've signed the state's application with a 2-week completion requirement. Do I have your original application yet, Mr. Schultz?
Did mine go up with you, or I think I might have handed the original back?
You know, yes, I will hand it up. I thought it was a copy, but I'll give that to the court as well.
Tell by that good heavy paper.
Yes, I was distracted by the quality of the paper. It is very nice.
Thank you, Your Honor. I'll go talk to you in a second.
Your Honor, did you want Mr. Kennedy to come back?
Essentially, everything's exactly the same.
No, I just signed the memorandum.
Send it back to him. I'll come and see you as soon as I get these copies. copy of the police reports. I don't think they're available. I tried to get hold of the prosecutor yesterday, but he was doing it. Got with him, see what I can get. Maybe it's in my file, and I just haven't seen it yet. So, yeah. All right, thank you, Your Honor. That's it.
Item number 10 on the criminal docket is Austin Dunn.
Your Honor, Mr. Dunn comes on today, 15-1013-88-2. We're on for omnibus in this case as well. I'll hand forward the state and defense omnibus applications. Ms. Rulli and I haven't had a chance to exchange those. Note for the record, the defense is endorsing no affirmative defenses would appear to be a denial at this time, and I think we would just need compliance 2 weeks prior to trial.
Trial's currently set for October 19th.
Yeah, that's what I was looking for. I'm trying to see the most recent scheduling order.
That should
There it is, October 19. 2 weeks prior to trial, sufficient for you, Ms. Rulli?
Yes.
Any other issues for the court to address?
No.
And one thing that we probably should address is I think the defense omnibus application requests a 3-5 hearing. We would need to have that, but I think we could do it the morning of the trial.
Yes. Agree.
All right, thank you. Which department is this?
This is
Three?
Department 2. Your Honor, actually.
2. Oh.
That's what my file shows in any event.
Yes, that's what ours indicates as well. Anything else? Okay, just a reminder, sir, you're still under whatever release order conditions are in effect as long as the charges are pending. Next court date, I presume, is readiness.
That's correct.
Thank you. See you then.
Item number 20 on the criminal docket is Christopher Tipton.
Tipton?
What's that?
Good one.
Ace Tipton? Ace Christopher Tipton. I apologize.
Thank you.
Christopher's the middle name, Your Honor.
Good morning, Your Honor.
This matter's on for arraignment.
That is correct. I've had the opportunity to review the information with my client. He understands the nature of the charges against him, would waive a formal reading, plead not guilty. In this case, Your Honor, I've already received discovery and an offer from the prosecutor that my client indicates he'd like to take. I'd like to put him on for change of plea October 5th at 1:30, and I have no objection to setting alternative trial dates.
Is there room on October 5th?
Yes.
Okay, we'll note that on the scheduling order. Then we will at the same time give you a trial date of November 18, which is a 49-day trial set. Readiness on November 12 at 1:30. But again, with the change of plea notation for October 5th at 1:30.
Your Honor, I would just note that Ms. Klein is not available on the November 18th date. It doesn't sound like it's probably an issue because we do have the change of plea date set on October 5th, but just to give the parties a heads up that the state would be moving for continuance if we did need to proceed to trial.
Thank you. So noted. So I put in change of plea on there as well.
Oh.
Thank you. And I need you to go ahead and sign right there. It just says that you will make all of those dates.
Mm-hmm.
Do I have a trial?
It's just in case you change your mind.
Oh, okay. No, I will worry about that.
Item number 19 on the criminal docket is Pamela Rick.
Thank you, Your Honor. Thank you, counsel.
This matter is also on for arraignment, Your Honor.
That is correct, Your Honor. I've had the opportunity to review the information with my client. She understands the nature of the charges against her, would waive a formal reading, plead not guilty today, and we'd ask for that same November 18th trial date.
Okay, we'll accept the not guilty plea. Give you an in-custody date. That's a short trial week because of a Wednesday. You think PCS should be able to be...
Correct.
Okay, November 18, that's a 49-day trial set. Readiness November 12 at 1:30. Is there any need for omnibus to be set at this time?
There's not, Your Honor.
You can cite that in later as needed. And you will get a scheduling order with these new dates.
Ms. Jeffers, are you covering Mr. Pasco's matters too?
I'm not. I have Mr. Martell left and Mr. Pasco's here on the other gentleman and ready. All right, Pam, I need you to sign here. It just says that if you bail out, you'll make those court dates. Failure to do so would result in additional charges and a warrant for your arrest.
Item number 22 on the criminal docket is Jordan Martell.
That's Mr. Pasco's.
That is mine, Your Honor. Although it's not the first time somebody's called me Mr. Pasco.
Well, he's lurking behind you here, so...
Mr. Martell. Your Honor, this is on for arraignment. I have reviewed the information with my client. He understands the nature of the charge against him, would waive a formal reading, plead not guilty, and that November 18th date still works for me.
All right, we'll accept the not guilty plea. Possession of stolen motor vehicle. We could give you the November 18, or we could give you November 16, which is the Monday trial set.
That's fine as well,
When we
Your
do
Honor.
that, November 16 is a 47-day trial set. Readiness November 12th at 1:30. Do you need omnibus set at this time?
No, Your Honor. Okay, so Jordan, we're just going to sign. It says that if you bail out, you'll make both these court dates. If you fail to do so, the charges and issue.
Give you the information. Should be going to go back in there.
Do you have a phone number for it?
Yeah.
I need you to go ahead and sign right there for me. Thank you, Your Honor.
Item number 21 on the criminal docket is Donsha Jackson. Matters on for arraignment, Your Honor.
Your Honor, it's a three-count information. My client would enter a plea of not guilty to each of the three counts and request trial be set within 60 days. There is desire on behalf of the defendant to talk and address bail. I'm a little hesitant to do that for the following reason. I did speak with the person who he'd be living with. His girlfriend is in the courtroom, not the person he'd be living with. He'd be living with his sister, which is what he told him originally. However, he had a DOC hold that I just learned was lifting on October 6th, so when I did speak to her face-to-face last time in court, I didn't confirm she could live, or excuse me, that he could live there. Is there a time the court could give me that both counts would be aware of that I could readdress bail?
Well, it's Department 1 case, but I think you could bring that in basically on any morning docket. Just
Okay.
provide written motion and an opportunity to respond. So I'll leave it to your discretion.
I just want to do it before October 6th, so do you have a problem with a short note? I mean, can this be enough notice that I'm going to do that for you?
Are you doing a specific date at this point, or
I mean, just a date next week before October 6th, if it's possible.
I'll make note in the file for the assigned TPA that you intend to
Yeah.
next week bring a motion for bail.
And then
reduction.
I've provided supervised release the number. So with all that, Your Honor, we wanted to plead not guilty today, but I just wanted to raise that issue while I was here.
Thank you. We'll accept the not guilty plea. We can give you a November 23rd trial date in Department 1.
Works for the state.
November 23rd, 54-day trial set. Readiness November 19 at 1:30. Does either side request setting of omnibus at this time?
Defense would, Your Honor.
May I suggest November 4th, 9 a.m.?
And Your Honor, could we go either a little later or before October 29, because I'll be out of town on November 4th?
Sure, we can give you October 27.
That'd be good. Thank you, Your Honor.
So let's indicate that on the scheduling order, an omnibus of October 27, 9 a.m.
They can't make you sign it, but it's polite to sign it. There's no reason not to.
Item number 7 in the criminal docket is Sergio Vargas Castro.
Go back now.
This matter's on for agreement, Your Honor. There is a case that's currently set for trial that's on today just for review purposes. It's set for trial on November 9th, just for purposes of setting within speedy on this case, Your Honor.
We do have new information we're in receipt of. It's a 2-count information alleging possession of meth and unlawful possession of a firearm. I'd like to waive formal reading and enter a not guilty plea and have trial be set. There is a previously scheduled trial, so I think we would have an excluded period for that current trial date.
Thank you. We'll accept the not guilty plea then on the 15-10-1777-2 case. And we'll give you a trial setting. Did you say November 2nd or November 9?
November 9th, Your Honor.
So excluded time up until November 9. In Department 3, we could then give you November 23rd.
That'd be fine.
That would be a 14-day trial set based on the excluded time under 3.3. Readiness November 19 at 1:30. Any request for omnibus on that case?
No, not at this time. Thank you.
I did. Yes.
Your dates, you know when to come. Get out.
Mr. Rucker, did you get notified there was an appointment yesterday afternoon that came in on our docket?
Yes, Your Honor, I did get the appointment, and we did meet with the defendant and do the discovery request yesterday.
Thank you.
I think we're just waiting for the next group of custodies to arrive, Your Honor. Does anybody else have any out-of-custody matters that are ready to go?
Wouldn't want it to be misinterpreted.
Yeah. No idea. First appearance.
You want to do that matter with Horton?
He's not down yet.
I think the group is coming.
is Dan Gasparino coming over?
Yes, and I told him to come at 10:30, so it should be here in time.
Yeah, he's down.
Item number 11 on the criminal docket is Douglas Horton. Here, this matter is before the court. It was originally on the 24th of September for sentencing. At that time, there was a scrivener's error in that judgment sentence was marked with 365 days. It should have been 366 days because it was a prison sentence, Your Honor. Additionally, the credit for time served should have reflected 69, or should reflect 69 days as of today, as opposed to the 64 days that was marked at the time of the judgment sentence. I've handed for a amended judgment sentence, Your Honor. I would ask Your Honor to sign off on that. I don't know if counsel has anything additional to add.
That's fine. It's my understanding.
Okay, so per the stipulation of the defense, the court will amend the judgment and sentence accordingly based on the state's representations. You said October 24th, but I think you probably meant September 24th.
I meant September. I'm sorry, Your Honor.
That's all right.
A little ahead of myself.
Okay, I've signed the order correcting and the new judgment and sentence.
I didn't.
I'll hand forward a memo as well.
We have the.
You'll have to step over here
Okay.
to sign the judgment sentence. Item number 13 on the criminal docket is Dante Smith.
Docket number again, please.
Your Honor, that is item number 13 on the
13.
criminal docket.
Thank you.
We are here for omnibus.
Your Honor, I'm handing up before both the state's and the defense's omnibus applications. I've reviewed the answers, and there are no issues at this point.
What's our trial date?
October 12th.
All right, what are we proposing as a completion date then?
Friday.
Discovery is essentially
Yeah, complete. I think discovery is complete. Well,
Friday the 2nd? Is that okay?
That works, Your Honor.
I'm sorry, I didn't do that.
Friday 2nd.
October 2 for completion date.
Thank you.
No other issues for the court to resolve at this time?
no.
No, Your Honor. Well, we will need a 3-5 hearing.
With Department 8. So you'll coordinate that with Department 8?
Yes, sir.
All right, thank you.
Thank you, sir.
Thank you. Let's go talk.
Items number 1 and 3 on the criminal docket is Bruce Schulte. Your Honor, my understanding is that the request of counsel is to set this matter, this omnibus over, however the omnibus was ordered by the court, and so that's why we did just simply strike it.
In addition, Your Honor, my client would like to be, if room is available, to put him on the change of plea docket for next Wednesday.
Shall we, is there room on next Wednesday?
Yes.
That's a PM or an AM?
That's a PM, I believe, Your Honor.
Wednesday PM docket. So should we simply strike omnibus at this time?
I would have liked to strike omnibus. There's no reason for it, Your Honor.
Okay, given the fact that it's being cited for change of plea, that would seem to be appropriate.
So that would be Wednesday, October 7th.
7th at 1:30. That'll be your next court hearing, sir, for change of plea. Yes, sir.
And there's 2 case numbers for him. There's a tracking PV, so if they can both
See
be on the
that.
docket.
Yeah. That's the 13 case 01057-7. That'll also track.
It just says we're next on the docket on the 7th. That's next week, okay?
All right.
There's two of these because you got two cases. You got this one and you got the tracking PV. Sign right there.
Signs from also.
What's that? Yes, please.
I need to hand the judge hasn't signed.
Oh,
Sorry.
Didn't see that yet.
I need to check.
Good thing you caught that. I'll come down and see you first part next week.
All right.
Okay?
Thank you.
Okay.
Thank
Oh,
you.
wait. You gotta get your copies.
Are you ready on Delgado?
Yes.
One more there, Michelle.
Item number 4 on the
Thank
criminal
you. Thank
docket
you.
is Valentin Delgado.
Sorry.
Your Honor, we were originally set for omnibus today. This is a case, though, that was set out for 47 days. There is probably over 20 witnesses, and so rather than omnibus, we're asking for a continuance. And my client has signed a waiver. I'll hand this to you. A waiver of speedy trial with a new commencement date of October 16th. If we can get the first part of December, that would be, I think we'd have all the interviews hopefully done by then.
State's position?
Yes, Your Honor. This is Clause 15-10066-6. I agree with Mr. Vukanovich. The case was set short, and it is a complex situation involving a lot of different victims. So I think a continuance is entirely appropriate.
Is that agreeable with you, Mr. Delgado?
The continuance?
Do you agree to waive your speedy trial rights and set a new commencement date of October 16?
Yes.
That'll give the state 60 days from that new date to bring the case to trial. You can't complain it's taking them too long, and that's okay with you? All right, we'll accept your speedy trial waiver then with that new commencement date, and we're in Department 9, so we could give you December 7. Was that one you requested?
That'd be fine, Your Honor.
December 7 would be a 52-day trial set based on that new commencement date. December 7 readiness, December 3rd at 1:30.
We should set another omnibus
I
date
was
at
going to
this point.
suggest.
I was going to say yes, that is correct.
How about November 18?
I think that would be good.
I think that, let me just double check, Your Honor. I think, yes, November 18th would be fine.
November 18, 9 a.m. Let's put that on the scheduling order as well for omnibus.
This is a new scheduling order. It says the omnibus hearing now has been moved to November 18th, readiness on December 3rd, and trial on December 7th. Okay? Turn around that line, please. Oops.
Thank you.
These are both for you, okay? Thank you. We're done. Thank you. Thank you, Your Honor.
Thank you.
Do you
have one additional in custody matter, Your Honor. Mr. Gasparino is on his way over to handle that. And I think we're just waiting for the next group of custodies to arrive.
All right. We can go off record.